Good afternoon. What's your name, sir?
Cornell McQuarrie, capital rest lowercase, not the all caps, sir, which legally denotes a corporation.
It's meant to show consistency when maintaining a public record of your own bad decisions. Hey guys, welcome back to today's video. We have part 1 of what will likely be a 3- or 4-part series covering a very serious and incredibly wild sovereign citizen trial.
Thank you, sir. I'm not the typist around here, sir, so we're going to go with it the way it's spelled.
May I please address the court, sir?
Sir, I'm sure your counsel would suggest that you not do that, but you have a right to do that if you want to over your counsel's very solid legal advice.
Judge, if I may briefly, Mr. McCreary did not want us to represent him. We tried to represent him. We would like to help him and represent him.
I'd like to represent myself, sir. Under Michigan Constitution, 63 Articles 13, represent myself, Judge.
As we always say on this channel, anyone who chooses to represent themselves in court is taking a huge risk. The old saying exists for a reason: self-representation rarely ends well.
All right, sir. It appears that you have a desire to represent yourself. Let me just ask you a few questions. You're aware that either right now or at any point while this case is pending, you can have the assistance of counsel should you so desire. Are you aware of that?
I am aware, sir.
All right, and it's your decision at this time to proceed without counsel, is that correct?
That's correct, sir. Appropriate pursuant under Michigan Constitution, 1963, Article 13, sir.
I always find it amusing when sovereign citizens cite laws and statutes as proof that laws and statutes don't apply to them. That said, it does make my job much easier. Michigan Constitution Article 6, Section 13, outlines the authority and responsibilities of the circuit court. From what I can tell, he's arguing that the case should be moved from district court to circuit court. However, the section merely grants supervisory authority to the circuit court over lower courts. It says nothing about a defendant having an automatic right to transfer a case simply because they requested it.
All right.
I am very
hold on, sir. Hold on. While you do have a right to represent yourself, you do not have the right to talk over me, sir. So let me say a few more things. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, which we've just discussed. And if you cannot afford an attorney, the court will provide one for you. In fact, we have several attorneys here today who are very capable. Of course, you can turn down that constitutional right, and it appears that that's what you're doing. Let's see. You're charged here with one count of misdemeanor assault or assault and battery. Maximum penalty is 90 days and or $500. And of course, going to enter a not guilty plea on your behalf, sir. We're going to hear a few words from the prosecutor, and then it'll be your opportunity to speak if you so desire. Mr. Prosecutor.
Thanks, Your Honor. Again, Steve Vincent on behalf of the people. The complaining witness, Your Honor, in this case is a police officer. Apparently, during prisoner transport, the defendant walked past the police officer who was in and around the area while the defendant was being escorted to the holding cell, and defendant took it upon himself to lean towards the police officer and spit on him. As a result of the defendant's actions, the people will be asking for $1,000 cash bond.
Mr. McCreary, anything you want to say as to bond, sir? I do caution you not to discuss the alleged facts of the case, but it's up to you.
Well, I first would like to challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. This is a structural error, Your Honor. Under MCL 767.24, Judge, this statute of limitations has told this is a structural error. This is prosecutorial misconduct under Michigan Rules of Professional Conduct 3.8, sir.
MCL 767.24 deals with criminal statutes of limitations in Michigan, and it's a fairly detailed statute. you'll need to be much more specific about which part you're relying on. Here's a little legal spoiler. The very argument you're making under MCL 767.24 is going to work against you later in this case. You also claim prosecutorial misconduct under the Michigan Rules of Professional Conduct, but you haven't identified any specific rule violation. So far, your argument seems to be that the prosecutor shouldn't be prosecuting you simply because you disagree with the prosecution.
I was in the Department of Corrections from, I believe it was I know it was 2002. I was released in August of 16. Paperwork, everything. I've been filing complaints against the prosecutor's office. Kim Worthy, where a judge heard it on appeal, Kirsten Frank Kelly. It's been crimes against me by the prosecutor's office. And I would like to move for a change of venue where it's clearly documented, Your Honor. And the statute of limitations has told, I don't know nothing about this case. Why wasn't I processed or liens checked before I was released from prison? I've been home 6.5 years, Your Honor. This is a crime in violation of misconduct in office, MCL 750.505. Also 18 USC 241, 242 per the federal statute. Embler versus Patchman, the prosecutor does not have absolute immunity. Judge, and I exercise the common law. I demand that this case be heard under the common law, Judge. I've been home 6.5 years. No threat to anyone. I've been working. I have had 5 children since I've been home. I'm a grandfather. I have 2 grandchildren, 1 on the way. And I've been trying my best, and people have been calling, making false complaints on me, and it's well documented. I've tried to press charges, and the prosecutor won't do anything. This is selective prosecution, vindictive prosecution as well. It's all documented, sir. And I ask that this case, I would like again to challenge personal subject matter and territorial jurisdiction. Under MCL 767.24, the statute of limitations have told they have been notified of any pending warrants or anything else while I was incarcerated before I was released. I've been home 6.5 years, haven't been a threat to the community, haven't been a threat to anyone. People have made false complaints on me, and I filed police reports with the Department of Justice, the FBI, the state police, and DPD, the 10th precinct. And it's documented, and they don't want to let me press charges. This is selective prosecution, Judge.
It sounds less like a legal argument and more like frustration that the prosecutor isn't pursuing charges against the prosecutor who handled your previous case.
So I asked for dismissal of this motion.
All right, motion to dismiss is denied. I don't have the authority to dismiss the case. The issues you raised, sir, are more properly brought before the judge who's going to hear this case, which will be Judge Bryant, and you can raise those issues at your next hearing. What I will do at this time is set bond as follows. Counsel, what was your request?
People were requesting $1,000 cash as a result of the actions in this case.
Okay.
I object. He just said outside. He's being vindictive, Your Honor. I object.
Sir, do you have any financial means with which to post a bond of any type today?
I have $300 on one credit card, and I have $40 on another card, sir. And I'll be more than happy to give you whatever I have. I've been trying, Judge. I have tenants. I have my home. I have kids I need to get home. I haven't been a threat to the community. People have been lying on me, Judge. And it's well documented, man. And I told myself on personal court. And again, I object under UCC 1-308. I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, and intentionally.
That argument might matter if this involved a commercial contract, but it doesn't. This is a criminal case governed by statutory law, not commercial law. Because of that, the UCC simply doesn't apply here, no matter which section you choose to cite.
Furthermore, I do not accept the liability of bill contracts. Also, I would like to cite a case to the court, Foy versus City of Berea, 58 Federal Third.
Sir, I don't mean to cut you off, but I do not have the authority to dismiss as you requested. So it doesn't do you any good to give me all the citations. You can raise all of that with Judge Bryant on your next court date, okay? So court's going to set bond at $1,000, 10%. That'll be $100 to you, sir, which you've indicated is an affordable bond.
I got my
And
card.
yeah,
Yes, sir.
if for whatever reason you don't post, you'll have an affordable bond hearing tomorrow morning. But if you do post, you don't have to worry about tomorrow morning. Your next court date will be in front of Judge Bryant on June the 7th, here in 36th District Court for a pretrial, and I'm sure that she will entertain your motions at that time.
All right, so that's the end of the... Hold on. Did you just say what I think you said? Please, continue. This should be interesting.
Can I ask you a question,
Go ahead.
Your Honor?
Yes, sir, go right ahead.
I would like to state this, that the prosecutor is under oath under Article 6, Section 3. Right now, they're violating their oath. There is a case called U.S. versus Will. When they have jurisdiction to act and they don't act, and if they don't have jurisdiction to act, it's treason against the U.S. Constitution, sir. Under the common law, I ask that you send this matter to the Michigan Attorney Grievance Commission judge because of misconduct on Kim Worthy and her subordinates.
Okay, sir. Again, that's something you can raise with Judge Bryant when you see her in June. Also, with regard to the bond redetermination date, that will be Wednesday, should you not post. If you post, you don't have to worry about it. If you don't post, that will be bond redetermination on Wednesday morning in front of Judge McConico here in 36th District Court. Thank you, sir.
I use my credit card.
In case you missed it, the last thing he asked was whether they accept credit cards. When it comes to posting bond and getting out of jail, it seems he's suddenly willing to acknowledge the court's authority. Many of you might be wondering how this situation started in the first place. Since he's being charged with crimes allegedly committed while already in custody, here's a quick preview of Part 2 so you can understand just how serious these allegations are.
Okay, we're on the record of the people of the state of Michigan versus Carnell Michael McCreary, in all lowercase letters. 2305645. Mr. McCreary is charged with count 1, assault and attempted murder. Count 2, assault and attempted rape by molested murder. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, and 9, weapons, felony firearm. Also count 10, weapons, felony firearm. Set for a motion here today. Appearances.
Edmonds to Milwaukee, B548 today, appearing on behalf of the people.
Mr. McCreary, you take it, please.
Carnell Michael McCreary Ill, all lowercase, acting appropriate for sign on the Michigan Constitution, 1963, Article 1, Section 13.
You're facing charges that include assault with intent to commit murder, assault, and multiple firearm-related felonies. Are you absolutely sure representing yourself is the strategy you want to go with? Earlier, I mentioned that citing MCL 7624 would come back to haunt him. Specifically, subsection 6 provides a 10-year statute of limitations for assault with intent to commit murder in Michigan. That means the argument that the alleged offense occurred 6.5 years ago doesn't help your case at all. The statute of limitations hasn't even come close to expiring. And with that, we really have reached the end of today's video.